A very good morning to all the participants. I am Amrinder Singh Shergill.
Good morning, sir.
I am an
Good morning.
good morning, ji. Good morning. I am an additional district and session judge from the Punjab State Cadre, presently on deputation as a faculty member. I'll be taking the first session. Great. And other sessions as per the schedule will be taken. Before starting the session, I would like to clear certain things. First thing is, it is basically on your request that this session is being done online. Otherwise, it was to be done offline. So request from Academy is, please remain connected. Otherwise also, you all officers were required and also expected to give the same session, to educate the same subject in your respective session divisions in the coming study circle. So if you will remain attentive, this is an interactive session. I can see your faces, you can see my faces. You can question me anytime, or you can question the other speakers also anytime. Clear your doubts, and only then you will be able to take up your sessions in the study circle in your respective session division. Okay. Anything you want to ask before starting the session? Great. Let us start with the session. First session is how to expeditiously dispose of execution cases. We all know that we do not give much importance to execution cases. The reason being, there is a 12 years period for getting an execution application disposed of. There is no number fixed ke only one application can be filed. There can be any number of applications within those 12 years for seeking the execution of a decree. What advocates normally do is they also withdraw the execution application if it is getting old or is coming in some action plan. So for one reason or the other, we do not lay much emphasis, much stress on execution cases. Now the Honorable Supreme Court has fixed a timeline within which an execution case is to be disposed of. That timeline has been fixed through a judicial direction. And that timeline is 6 months. I don't think there is any requirement of making you aware that what is the consequence of non-obedience of a judicial direction given by the Honorable Supreme Court. So we have no other option but to make every attempt, every endeavor to dispose of the execution cases within 6 months. If for one reason or the other, we are not able to dispose of a case within that stipulated period of 6 months, what the Honorable Supreme Court has directed us is we have to record reasons in writing as to why we could not dispose of the case and why we are adjourning it. Great. Now, in this aspect, in this session, I'll be touching few areas. First is to sensitize you that when does a case comes up before execution, the journey which it has traveled and the points which it has got adjudicated. Then is your involvement in scrutinizing the application before proceeding with the application. That is also a very important stage which we do not, care that much. Then comes the stage of issuance of notice. It is not that each and every case notice is required to be issued. Thereafter is the stage of issuance of process. There are certain requirements casted upon us by the statute as well as the rules and orders of the Honorable High Court. Before issuing a process, we have to make sure certain things. Like an example, you issue a warrant to attach somebody's property. The warrant comes back unexecuted with the report that that property is not belonging to the judgment debtor, or that property is not attachable under law. That will result in wastage of precious time and your 6 months timeline will be affected. Then is after knowing the provisions, the last and the most important aspect is your firmness, your intention, your resolve to act upon those provisions, to apply those provisions, to dispose of the execution case within a period of 6 months. Great. This will be my journey within this session. The first thing is to sensitize you as to when an execution case comes before a court for seeking the execution. You see, every case is divided in 3 stages. First stage is initiation of a litigation by filing a civil suit through presentation of plaint. Second stage is the adjudication of that very litigation, giving notice to the defendant, obtaining written statement, disposing of miscellaneous applications, framing issues, uh, availing the ADR mechanism modes, then holding the trial, recording the evidence of both the parties, and then giving the judgment on the basis of which a decree is to be drawn. After the finality of the adjudication, then comes the third stage with which we are concerned in the present session. That is the implementation of that very adjudication. That is execution of the decree which is passed, which is framed on the basis of the crux of the judgment. So the execution is filed before a court for seeking the implementation of a decision of an adjudication which has attained finality. First appeal, second appeal, whatever are the appellate forums available for a litigant, he has availed all those opportunities. Now the litigation has become final. It is before you for its execution, for its implementation, for its enforcement. Then I would like to sensitize you that what happens in the second stage of adjudication. You see, we are governed by the Code of Civil Procedure. It is a systematic code. It has Order 1. Order 1 talks about the parties in a civil suit. The overall crux of the Order 1 is that all parties which are interested in the subject matter of the civil dispute or in whose presence that civil dispute is required to be adjudicated should be joined as parties to the suit, so that when a civil suit is sought to be adjudicated, any party which has any right, title, or interest in the civil suit in that very list, in that very dispute, is either made a party, or if that party comes with an application, I'm talking about Order 1 Rule 10, then that application is to be allowed if that party is a necessary party in whose presence the adjudication can be effectively adjudicated, can be decided. So all those parties which have any right, title, or interest or its semblance are made party in a civil suit who finally got adjudicated and comes before you for implementation. Then comes Order 2. It tells us that all the reliefs which the party wants to obtain or which he can obtain, that are to be joined, that are to be taken in that very particular suit. If a party can obtain a relief, but that party does not plead or pray for obtaining that relief, that means he has abandoned that relief. For the same relief on the same cause of action, no second suit can be filed. So by talking about Order 1 and Order 2, I would like to sensitize you is that when a litigation gets adjudicated finally, it gets adjudicated in the presence of all the necessary parties. And it gets adjudicated as to all the disputes which the parties can have or actually have. All the causes of action, all the reliefs, whichever are available to the party, that stands adjudicated. Once all the parties in a suit got all the disputes adjudicated, then there remains nothing before you but to implement that decision. We often start a mini trial by raising of a third party objection by a party which is not party to the litigation. What section 47 of the Code of Civil Procedure tells us is the questions which can be determined by an execution court before reaching the Order 21. It talks about few things. First is the executing court can only see those questions, those disputes which are in between the parties to the litigation. If that is the scenario, referring Order 1 and Order 2, that dispute stands already adjudicated. Or if a party has not obtained that relief, he has abandoned that relief, he is barred to re-agitate it again and again. There is no need to entertain such an objection. Then is regarding the matter in execution, the relevant to the controversy, only then you can entertain the objection. Otherwise, the objections are not to be entertained. Thirdly is there is a magnificent provision in the Code of Civil Procedure, that is section 151. It talks about the inherent power which every civil court has in it, by exercising which you can administer justice or you can undo injustice. What can be administering justice other than implementing a judgment which has attained the finality? We hesitate in invoking, in applying section 151. It has to be applied. It is the part of the statute. It is a statutory provision. Then is the applicant decree holder has to move an application through which that decree holder is to seek the assistance of the court in execution of the decree. In case that decree holder does not do the required act, for an example, he wants the decree to be executed through attachment of some property of the judgment debtor. What he is required to give is the list of the property which he intends to get attached. Then is the proof as to whether that property is owned by the judgment debtor. Who is the owner of the judgment debtor? Then is the warrant fee. Unless and until he files these three things, we cannot issue the warrant of attachment. What we do is we keep on giving dates. Advocate says, sir, date de do, ugly date de dena, sir, date de do, ugly date de dena. Just keep in mind, we have just 6 months to finally dispose of the execution application. So we don't have any time for giving unnecessary adjournments. There is a provision which I'll be referring. Invoke that provision, dismiss the application. The decree holder, no prejudice will be caused because he can always file a fresh execution application. Then is if the judgment debtor does not do it, the court empowers you. 151 is there. And you can also impose costs also, which we, normally do not impose. Or if we impose it as very nominal, 50 rupees, 20 rupees, 100 rupees, which is no a cost in these days. Whatever I am telling, I am not telling as per, my wish. This is what has been laid down by the law, by the pronouncements of the Honorable Supreme Court, or which is otherwise given in the statutory provision. First thing is that which judgment has given us the time that we have only 6 months. If we are not able to dispose of the execution application within 6 months, then what we have to do? That judgment you all must be knowing is Rahul S. Shah versus Janendra Kumar Gandhi and others. The citation is 2021-6 SCC 418. In this judgment, the Honorable Supreme Court has said a civil court has 6 months timeline to execute the decree. Then recently, this thing has again came up before the Honorable Supreme Court. The case is Dr. Bhojraj Garg versus Goyal Educational and Welfare Society. The citation is 2022 Live Law Supreme Court 977. The Supreme Court has said that direction is meant to be observed, not a formality. The Honorable Supreme Court requires, expects, and mandates that the said direction of disposing of an execution application within a period of 6 months is to be observed in its letter and spirit. In Rahul S. Shah, the basic judgment which was endorsed in Dr. Bhojraj case talks about certain things which were already there, but they were in a sense re-emphasized by the Honorable Supreme Court. First thing the Honorable Supreme Court has said is use your powers. A civil court is empowered to administer justice. There are so many provisions given in the Code of Civil Procedure. If there is no provision, then invoke section 151. That is the mother of all provision. Provided you have an intention to administer justice. This provision is to be used, not to be misused. Then is Honorable Supreme Court says that parties are expected to cooperate with the executing court. If a timeline is of 6 months for an executing court, it is also in the notice and knowledge of the parties. They should assist the court in disposing of the execution application, in satisfying the decree under execution within that period of 6 months. And if either of the party do not give the required cooperation or the assistance, then the Honorable Supreme Court is saying, I'm not saying, Honorable Supreme Court is saying that the civil court should proceed to use its power. We are not helpless if a party is not cooperating. If the decree holder is not cooperating, we can always dismiss the execution application. If the judgment debtor is not cooperating, we can impose the cost. Otherwise, the statutory provisions, we can detain.
Excuse me. So you're not audible.
Excuse me, sir. You are not audible.
So we missed the last
Sir,
portion.
you are not audible, sir.
Not audible, sir.
Not audible, sir.
Am I audible?
So
Yes,
sir.
audible.
What was the last thing which I had mentioned?
so that we can dismiss the application of the decree holder, and for the JD we can impose the cost if he is not cooperating.
As well as for applying section 151 CPC.
Okay.
Yes.
That you have heard that parties are expected to cooperate.
Yes, yes, sir.
If
Rather
they do
than-
not cooperate, then we can use the power.
Yes, sir. Yes,
So we were talking about the cost. The Honorable Supreme Court has used words suitably heavy cost. Not cost as a joke, but cost should be heavy so that it pinches the party which is not cooperating, which is not part performing its part. Then is Honorable Supreme Court says is it is only possible if a court plays an active role. If you monitor and play an active role in the each and every stage of the proceeding, then you have the control over the case. This thumb rule is applicable to all categories of cases. Only then you can control your case, its adjournments, its disposal. Then is the court should see whether if an application is moved by either parties to the litigation, that is decree holder or the judgment debtor, or any third party, whether that very matter was ever agitated during the pendency of the suit or during the stages of the appeal. If it was so applied by either of the parties or by the third party, and that application stands dismissed, then we have not to entertain such an application, which was filed, dismissed, which could have been filed but was not filed. Such an application, such an issues are not to be re-adjudicated. Then is how to adjudicate if an issue, happens to or is required to be adjudicated. The Honorable Supreme Court says is appoint a commissioner. Don't call evidence in all the cases. Don't frame issues and start a mini trial. Call the photographs, call the videos, and call the affidavits. And on the basis of these four things, this is Rahul S. Shah judgment's dictate. On the basis of these four things, adjudicate whatever is the matter. So if a genuine third party objection comes, then that third party objection can be adjudicated by appointment of local commissioner, by calling the photographs, videographs, or affidavits of the party. Then is section 165 of the Indian Evidence Act, where the court can question anything to clear the doubt. Now coming on to the anybody having any query as to this basic, introductory background of the start of the litigation. Now coming on to the stage 1, when the execution application is filed before the court. You see, Rule 10. Now I'm on Order 21. Rule 10 says there has to be an application if somebody wants the execution of a decree. Rule 11 says there can be a written application, there can be an oral application. Oral application, we practically do not receive any oral applications. There can be an oral application, but we are focusing this session on the written application. Sub-rule 2 of the Rule 11 talks about the written application. It details as to what facts and what formalities have to be completed by the applicant, by the decree holder in that written application. Then is Rule 17, Sub-rule 1 of Order 21. It casts upon a duty on a civil court to check whether all those requirements have been fulfilled, and if those requirements are not fulfilled, then to give a short adjournment, one opportunity for fulfilling the requirement. Like somebody has not, attached the certified copy of the decree under execution. Somebody has not filed the list of property. Somebody has not filed the ownership proof. Somebody has not filed the warrant fee, warrant charges, process fee. Then Rule 17 and Sub-rule 1A of the Rule 17 says reject the application. Don't take it on you. Don't give unnecessary adjournments for rectifying or for fulfilling those shortcomings. Invoke Rule 17, Sub-rule 1A, which empowers you that if you have provided a reasonable short time to the decree holder applicant to rectify the shortcoming, and if he has not rectified it, then you have to reject the application. The qualifying word is shall not may. So only entertain that application which is complete in all aspects. Otherwise, we are having a 6-month timeline. There is a provision in the Honorable Rules and Orders of the Honorable High Court. I'm talking about Rule 13, Volume 1, Chapter 12, Part E, which is a chapter dealing with the procedure of application for execution. Rule 13, Volume 1, Chapter 12, Part E. It says that if the decree holder applicant does not take the necessary steps in the prosecution of his or her execution application, the execution case is to be dismissed. This provision can be applied at any stage of the execution case. If and when you ask the judgment debtor, the decree holder applicant to do something, and he does not do that thing, invoke the provision of this rule and orders of the Honorable Punjab and Haryana High Court, Rule 13, and dismiss the execution application. Don't keep it pending. Otherwise, you will be in a 6 months timeline. Then we have crossed the first stage. We have checked that all the requisite particulars are there. It is a complete application in all aspects, and it has to be entertained. Then comes the stage whether the notice is to be given to the judgment debtor or not. Rule 22 deals with such a situation. It says a notice is not required to be given if the application for execution is filed within a period of 2 years from passing of a decree. Now stepping into the shoes of the decree holder. Decree holder has presented a plaint before a civil court whose notice was given to the defendant, written statement was obtained, applications were disposed of, issues were framed, evidence was taken, and it was finally a judgment which was passed and decree was drawn on the basis of the judgment. Then the loser preferred the first appeal, then the second appeal, then maybe before the Honorable Supreme Court also. You see, if a party has wasted so much of the time and energy in obtaining a judgment and obtaining a decree, practically he will not be wasting those 2 years from approaching the court. He will then and there, as soon as possible, within a period of 1 month or few days, he will approach the court. So practically we do not have any case where a party who has obtained a decree after so much of the efforts is lying sleeping in his house and is not approaching the court with an execution application. So if that is the scenario, in that case, we are not required to issue any notice to the judgment debtor. In which cases the notice is to be issued where the decree was passed against somebody, but before the filing of the execution application, that judgment debtor has died, that defendant has died. Now the decree is to be enforced against the legal representatives of that deceased defendant judgment debtor. Since legal representatives' liability is only to the extent to which it has inherited the property from the judgment debtor. So if a judgment debtor has died before the start of the execution, which is to be enforced against the legal representative, then the notice is required to be given. Otherwise not. If during the pendency of the litigation, the defendant has died, then his legal representative has already come on record. The adjudication has taken place in his presence. Then there is no requirement to issue the notice. Then is where a decree was passed in reciprocating territory to which we have reciprocating agreements some other country. That is always not a practical case. Or the judgment debtor against whom a decree has been passed stands declared as insolvent in the insolvency proceedings, and somebody has received the insolvency rights. Since his liability is limited, like the case of legal representative, in such a scenario, the notice is required to be given. If practically speaking, out of my experience of 23 plus years, there is hardly a case, they may be 0.001%, 0.5%, or at the most 1% of the total execution cases. In rest of the cases, in normal cases, since the judgment debtor will not, the decree holder will not waste the time in approaching the court for seeking the execution, there is no requirement of issuance of the notice and wastage of time. Otherwise also, if a notice is to be issued, please pass a composite order. Composite order means, in first stage we issue the notice, then the notice is returned back that the respondent was not found available in the house. Then in the second stage we direct the process server that it be served on the adult member of his family. Then the process server comes back again, KG adult member of the family was also not available. Then we pass an order, it be affixed on the outer door of the address. So always pass a composite order that the service should be effected in person. If the respondent is not found available in person, it be served through an adult member of the family of the respondent, or in case it is also not possible, then the notice is to be affixed on the outer door of the address, witnessed by a respectable person of that very locality. That will, save 3 dates at least. and then I'll be telling you the provisions of the Honorable Rules and Orders of the Honorable High Court that a process server is duty bound to keep on going, keep on attempting. He is not supposed to go once and that is all. He has to go any number of times until the service is effected. So if we incorporate that direction in our judicial order, it becomes a judicial order and its enforceability is its sanctity, it gets raised. We can call anybody, we can, check anybody that you have not obeyed a judicial order. Though the provisions in the rules and orders are also to be obeyed, but if we specifically mention it in our Zimni orders, in daily proceeding orders, it has more effect. Then there is a provision to this rule which talks about issuance of notice. It says if the court is satisfied through an affidavit or otherwise, which is always a case, that issuance of notice will result in unreasonable delay or will defeat the ends of justice, then there is no requirement of issuance of notice. That means those 1% cases or 5% cases where the notice is required to be issued, but the decree holder, the applicant moves an application supported by an affidavit that if we issue the notice, the time will be wasted, it will unnecessarily delay the matter, and it will, defeat the ends of justice. Through his affidavit, through that very contents of the affidavit, we can satisfy ourselves and directly issue the process. In my opinion, with the invoking of this proviso, in almost all cases, there is no requirement of issuance of notice, practically. Then is, if the notice is not to be issued, directly the process is to be issued. If the person is to be arrested and detained in the civil imprisonment, that process. If a property is to be attached, that process. If the property was already under attachment, it is to be sold, that process. That means after satisfying yourself that all the requisite particulars are there in the execution application, without giving notice, you can directly issue the process. That means 6 months are more than sufficient for implementing a execution case, implementing the outcome of the decree, enforcement of the decree. Now, there is also a filter as far as the processes of executions are to be issued. Rule 24 says, after all those preliminary measures which we have talked about, once they are completed, then issue the process. Issue the warrant of attachment. Issue the warrant of sale. But please specify 2 different dates specifically in your warrants. First date should be the day on which that process is to be executed. And second day is that day on which it has to be returned to your court. We normally issue the warrant of attachment or property of the judgment debtor is issued for, that is the next date of hearing. This is not the spirit of the law. Rule 24 says, fix 2 different dates, one date for the execution of the process and second date for returning of the process or the adjournment to which that case has been adjourned. Then is important is Rule 25. Rule 25 says the bailiff or the process server to whom that warrant or that process is marked, has to give his endorsement, has to, give his report the day on which it was executed, the manner in which it was executed. And if for any reason he is not able to, execute the process, why the delay has occurred, the reasons for the delay. Or if he has failed to execute it, why it was not executed. And rule 25 sub-rule 2 says that in case a delay has occurred or in case a default has occurred in the execution of the process, examine that process server and bailiff to satisfy yourself whether his fault is intentional or is unintentional, whether it was practicable for him to execute the process or whether it was beyond his capacity. If you are satisfied that he could have executed but he has not executed, please take him to logical end. These are only the process servers and the bailiffs through whom we execute our processes. If we do not monitor their endorsements, if we do not call and examine them, if we do not keep them tight, they will they are not bound by the direction of the Honorable Supreme Court. It is the court which is accountable for the delay, not the process server. Then there is a provision in the Honorable Rules and Orders of the Honorable High Court. It is Rule 4, Volume 1, Chapter 12, Part H. It talks about the process of attachment, but the principle we can always borrow. We have Section 151, the inherent powers. It says, when a warrant of attachment is to be issued, the court is required to obtain a note from the reader of the court. What the reader is to report is that the process which is put before the presiding officer for signatures is complete in all respects. The property under attachment is capable of attachment under law. We have Section 60 CPC. There are properties which can be attached. There are properties which are exempted from attachment. So reader has to give a note that the warrant is going to be issued against a property which is capable of attachment under law. Then is the list of property is also filed. The ownership proof is also filed. Somebody gives the registration number of a motorcycle or a car. You issue a warrant of attachment. Ultimately, that motor car or that motorcycle or car happens to be in the name of the spouse of the judgment debtor, JD's wife or JD's husband. Then technically you cannot attach that property because the judgment is not passed against the spouse who is holding the property. This is to be verified by the reader. Please ask the reader to give a note after verifying all those things before putting your signature. This is the mandate of the law, the rules and orders of the Honorable High Court. Then is Rule 1, Volume 4, Chapter 7, Part B, A. It deals with service of process, mode of service. Under this rule, there is a duty casted upon the process server to make every attempt for the personal service. Attempt is go again and again. That means if a respondent is residing at a particular place, the process server is duty bound under this provision to go again to effect the personal service. But if within the given time, the respondent by going again and again is not found, then is serving the process through an adult member of the family. Otherwise, to affix it on the outer door of the address. The process server may or may not be knowing these provisions, or even if he is knowing the provisions, he may or may not, want to do it. He can be, win over by the opposite party. Lick the report, the respondent was not found available. If you will, in your Zimni order, mention the provision and mention the different steps which the process server is required to follow. And in case you do not follow that steps, you can always, examine the process server to satisfy yourself that whether he has honored your competent order or honored your or followed your direction given in the in the order which you have passed, which is a judicial order, or has willfully disobeyed it, then to prosecute or to take these steps against him. Then is in the processes there are certain officials which are duty bound to assess the process server. In villages, we have chowkidars which are appointed under the Punjab Chowkidara rules. There are lambardar, we call it as headman, that is appointed under the Punjab land revenue rules. They are duty bound to assess the process. And in case they neglect in doing their duty, the provision is there, Rule 1, Volume 4, Chapter 7, Part G, they have to assess the process server in the service of the process. And if they do not assess the process server, then there is Rule 11 under the Punjab Chowkidara rules, and the other rule is Rule 16 of the Punjab Land Revenue rules. For the neglect of their duties, for the misconduct, they can be terminated from their services. You only have to write a letter to the Deputy Commissioner, the District Collector. See, if you want your cases to be disposed of in 6 months stipulated time, you have to take these steps. Though they will take few minutes of yours, but it is worth giving. The rest of your cases will get smoothened, will fall in line. Then sometimes a question is asked, Keji, Munadi fee is too less. Nobody is ready to effect the Munadi. The drummer wants more money. If such a situation comes before you, then who is to pay the extra money? The extra money is always to be obtained from the person who has knocked at your door, who is the applicant, who is the decree holder. But if in execution of a decree, in the execution application, the decree holder is incurring certain expenditure, ultimately it is to be obtained from the judgment debtor. It will become a cost of the litigation. But initially, it has to be obtained from the decree holder. Then is the cases of arrest and detention. You see, there are two different categories of cases where a different procedure is followed. First category of cases where the decree under execution is a money decree. Certain amount of money is to be recovered from the JD. Then the law says, if we have to give notice to the JD, we have to call him, we have to make an inquiry as to what are his resources. We can also examine him under Rule 41 as to his resources. He is only to be detained, to be sent in civil imprisonment once he has resources and he is intentionally not paying the decretal amount in spite of having resources. But if he is insolvent, he is not having any resources, such a person cannot be detained in civil imprisonment. Rather, the provision is it is the duty of the civil court, once the JD comes before the court, to intimate him if he has no resources, if he is insolvent, then he can move an application. And once if he is declared insolvent, he is not going to be sent to the civil imprisonment. But this inquiry, a procedural step is only to be followed where the warrants of arrest are issued in a decree which is for the recovery of money. There can be a judgment or a decree of permanent injunction, of a mandatory injunction. There can be a case of non-observance of an order or violation of the direction of your. Then also there are provisions that you can detain the wrongdoer, the JD, in civil imprisonment. For doing that, as a punishment, there is no need for issuance of notice. There is no need for making an inquiry. So as a thumb rule, appreciate the differentiation. If it is a money decree, then we have to see whether the JD has sources or not. If he has sources, only then he is to be detained in the civil imprisonment. That in spite of having sources, in spite of having money, he is not intentionally paying it. But if he is not obeying he is not vacating the premises, he is unnecessarily showing the resistance, then he can be detained in civil imprisonment. Directly, the warrant of his detention, his arrest will be issued, and he will be sent to the civil imprisonment. There is a limitation period up to which the civil imprisonment can take place. Section 56 deals about it. Please, you always observe those limits. You see, if there is a decree for specific movable property, Rule 31 says it can also be done through detention of the wrongdoer, the JD, in civil imprisonment. Then for specific performance, you can detain a person. Then for restitution of conjugal rights, you can detain a person. Or in a decree of injunction, you can detain a person. Only for Rule 30, that is the procedural step of making an inquiry. For Rule 31, Rule 32, or making your orders to be obeyed by the parties, including the JD or somebody in possession of the property, there is no need for making an inquiry. You can directly detain that person in the custody. You see, there is Rule 41, Sub-Rule 3. If anybody disobeys your order, any order, it can be a JD, it can be a third person, then you can detain that person up to a period of 3 months, not obeying any order. Rule 41, Sub-Rule 3. Or showing resistance by the judgment debtor, or putting some obstruction in getting the possession of the property, in getting the vacation of the property, then you can detain such a wrongdoer for a period of up to 30 days. Rule 98, Sub-Rule 2. Please invoke these rules. If anybody is showing any obstruction, is not obeying your order, directly detain him in civil imprisonment, directly send him in civil imprisonment. There is no need for making any inquiry as was required in a money decree case. In case we are holding an inquiry, then also we have to, give a notice to him. And JD comes and JD disputes that he is insolvent or he has no resources. Then we have to release him by obtaining a security to our satisfaction that during the inquiry period, he will keep on coming. We can always obtain any security which is, in our opinion, sufficient for that inquiry period also. If he does not give the security which we have asked, we can always detain him in civil imprisonment. You see, there is also a proviso to this rule. I'm talking about Rule 37, which talks about issuance of a show cause notice to the JD before detaining him in civil imprisonment in a case of money decree. There is a proviso under which if the decree holder applicant gives you an affidavit or you are otherwise satisfied that the notice will result in delay of the execution application, or the notice will result in giving a time to the judgment debtor that he will abscond, he will run away, or he will leave the local limits of your court, or his intention is, to obstruct the implementation of the decree, the execution of the decree. If that is the scenario, through an affidavit or otherwise you are satisfied, then there is no case of issuance of notice. You can directly issue the warrants of arrest. But as a person with little experience, you see, don't get satisfied on the sole affidavit of the judgment of the decree holder applicant. Please make an inquiry as to his resources. If a person has resources and he then do not honor the decree, do not pay the amount which is, obligated under the decree to pay, only then detain him. Otherwise, don't detain. Then is Rule 41. Please follow it. It talks about the examination of the JD. It is not in all cases that decree holder will know that what resources the JD has from which the decree can be satisfied. There can be resources which is only in the knowledge of the JD who is to pay the money. Then that can only be done by examining the JD. Rule 41. Please invoke this rule and examine the JD. And the remedy is also given in this very case. If the JD refuses to answer your questions or to appear before you, then you can detain such a defaulter JD for a period of 3 months. Rule 41 itself provides so. Then is a woman cannot be detained in execution of a decree. Only in money cases. But if a woman is not obeying your order, is not obeying your direction, then she can be detained. But if a money decree has been passed against a woman, then it can only be executed by attaching and selling her property, not by detaining her in civil imprisonment. Section 56 says so of the CPC. Then is you cannot order a warrant of arrest if the amount to be recovered is less than 2,000. I am talking about section 58. And if the amount is more than 5,000, then the detention period is only up to 3 months, not more than that. If it is from 2,000 to 5,000, then only up to 6 weeks. A person who has been detained for a period of 3 months, when he has not paid the money which is more than 5,000, then again he cannot be arrested. But the debt will remain, the JD will not be discharged from the debt. But he cannot again be sent to the civil imprisonment for those 3 months for which he could be sent for the first time. Anything which you want to, because we are nearing the time, any query you are having? I'm seeing certain faces. Jitendra Singh, SDGM, Loharu, Chitesh, Hemamrit Mahi, Munish Nagar, Vivek, Kapil Sambarwal. Anybody? Because whatever I'm telling you, you have to tell your colleagues in your session divisions in the coming.
Good morning, sir. I am Hemamrit Mahi.
Good morning, Hemamrit ji.
Sir, I have a query with regard to subsistence allowance. Sometimes there is an confusion whether it is to be deposited at the jail premises or at the court. So there is a little confusion regarding subsistence allowance with regard to Order 21, Rule 37.
Otherwise, what is the amount of the subsistence allowance? You are clear?
Sir, we usually, sir, in as per Honorable High Court rules and orders, it's a very nominal amount.
How much is it?
Sir, exactly, I do not remember, but we usually get it some rupees 50 per day, like that.
You see, every state has a notification under which that amount is fixed. Haryana has a different notification. Punjab has a different notification. The subsistence amount is to be fixed as per that very notification. Then is its payment. If the process is yet to be issued, if the warrant is yet to be sent, the subsistence amount is to be deposited in the court. If the process has been issued, the JD is being taken to the jail premises, then in the jail premises. Only thing
Thank
is
you,
it has to be deposited. If it is deposited in court, if it is deposited in jail, it is deposited to the state, not to any person individual.
Thank you, sir.
Only requirement is it should be deposited. If it is not deposited, then the decree holder is not part performing his part, then you have the remedy. You can, dismiss such an application. You can reject such an application.
Yes, sir. Thank you, sir.
Yes, other officers, I'm also seeing Meenakshi Gupta, Tarannum Khan.
Good morning, sir.
Good morning, ma'am.
Sir, my query is that if, as you said earlier, that under the provisions of Order 21 Rule 37, if we have sent the JD for 3 months,
Yes, ma'am.
then he will be released after that 3 months.
Yes, ma'am. He is to be released.
उसके बाद सर कुछ
You have to mention in your warrants that he be detained for a period of 3 months or unless and until released earlier.
Yes, sir. Thank you so much.
Jitendra Singh, Joharu.
Good morning, sir.
Good morning.
No query, sir. Thank you very much.
The coffee time was yet to start. You are already having good. Kapil Samarwal. Okay. All the best. Enjoy your day. Hope
Sir?
you have. Yes,
Excuse-
yes, yes. Yes, Samiksha.
Uh,
Yes, yes.
Sir, I have a little query regarding
Please,
to
please,
warrant of possession.
Yes,
Like
ma'am.
in an execution, warrant of possession went, and for that I ordered that lock of the premises should be opened,
Yeah.
and for that necessary police help was also given. To
Hmm.
that, I got a report that the police is not cooperating. They have stated with the fact that only they can do this in the presence of a duty magistrate. Is there any requirement like that?
No, 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 not at all, not at all. I was missing this thing. I was telling you that there is a provision, section 151, inherent powers. You can pass any order to do justice. We are doing implementation of an adjudication which has attained finality. So we are very much clear if we are implementing the judgment. That is the justice of the highest order. Then is for implementation of our order, we can obtain the police assistance. We can direct the police assistance. Earlier, as per the rules and orders, we have to move a request to the learned district and session judge. Then the learned district and session judge should, send the request to the SSP. Then the SSP has to mark that request to the SHO. It used to consume the time. Rahul S. Shah says, the judgment which I had discussed earlier, you can directly ask the local station house officer, SHO of the police station, to provide whatever help is required. If 10 people are required, to mention in your order that give 10 people. If the women force is also required, mention in your order that along with 2 or 3 women constables also. And if that SHO do not honor your decision, you do not honor, do not respect, do not obey, do not fulfill your direction, then the Rahul S. Shah says you have to prosecute him directly. There are provisions in the IPC where willful disobedience to a order of the court is an offense. Invoke those provisions. Don't leave any SHO, doing whatever they want to do. If by, consuming your 10 minutes, 15 minutes, you will pass one order in one case, rest of all your cases will fall in line. The time which will be saved in other cases will be much less than the time which we have, a kind of wasted in one case of maybe half an hour, maybe 15 minutes. So these things are required. If you examine a process server and then, initiates a proceeding to punish him, all the process servers will come to know that this is the code which is not going to take us lightly. They will fall in line and you will see a resultant change in the service of your processing. Once your processes are served, your case is on the trail, it can move ahead. Yes,
Thank
very good. Samiksha, I was missing it, sorry.
Thank you so much, sir.
Any other officer?
Good morning, sir.
Good morning, Kapil.
Sir, I have a query regarding the execution of ex parte decrees. Sir, it does happen many a times that in the execution of such decrees, JD appears and he files an application to sine die the proceedings just because he has filed a 913 application for setting aside the decree. Sometimes they file in the executing court, sometimes they file in the court where this 913 petition is pending. Sir, how to deal such matters? I mean,
You see,
we cannot deny the
I have-
proceedings of the.
I have sensitized that there is order 1, there is order 2. There is a stage when the person can join the proceedings,
Ji, sir.
and if he does not join, it is his fault. Then he can obtain all the reliefs. If he is not obtaining any relief, it is his fault. We are not liable for that case. You know, unless and until there is a stay by a superior court or the court which has passed that very ex parte decree, you are not to stay yourself, you have to proceed.
Right, sir.
We are implementing a judgment. If the judgment is in force, if the decree is in force, we have to implement it. We cannot go beyond the decree, fundamental thumb rule. It has attained finality. The list has got adjudicated finally. We are just implementing it. Invoke 151, provide the police assistance, you know, make your proceeding effective. 6 months is a sufficient time within which a proceeding can be, you know, finally disposed of or execution can be satisfied. Yes, any other officer? Please enjoy your tea break. We'll be meeting at 11:45 a.m. with the second session on revenue law. Okay. Have
Thank
a
you,
good
sir.
time.
Thank you, sir.